Please subscribe to the channel to watch the latest videos.
Special counsel urges judge to deny Trump's January 6 claim of immunity. The defendant is not above the law, prosecutors say in opposing former president's bid to toss out federal 2020 election subversion prosecution. U.S. prosecutors urged a federal judge Thursday to reject former President Donald Trump's claim of absolute immunity from criminal prosecution for actions he took in office, saying that he is not above the law and that his indictment for allegedly conspiring to block the results of the 2020 election should not be dismissed. No court has ever alluded to the existence of absolute criminal immunity for former presidents, Assistant Special Counsel James I. Pierce wrote in a 54-page filing. The filing argued that legal principles, historical evidence, and sound policy reasons establish that once former presidents leave office, they are subject to federal criminal prosecution like more than 330 million other Americans, including members of Congress, federal judges, and everyday citizens. Trump lawyers John Lauro and Todd Blanche moved to toss out his indictment October 5, claiming that the Constitution, Supreme Court, and hundreds of years of history and tradition made clear that a president's motivations were not for prosecutors or courts to decide, but that where the president's actions are within the ambit of his office, he is absolutely immune from prosecution. In a dense response with 8 pages of legal citations, prosecutors argued that that claim turned the law on its head, just as they said it drew a false parallel between Trump's fraudulent efforts to overturn the results of an election that he lost and the likes of Abraham Lincoln's Gettysburg Address and George Washington's Farewell Address, adding dryly, "These things are not alike." Instead, they said the Constitution's separation of powers principle should apply to presidents like it does to judges, who enjoy absolute immunity from civil damages liability for certain conduct in office, but remain subject to criminal laws. The indictment alleges that the defendant acted deceitfully or corruptly to secure a personal benefit to himself as a presidential candidate, not to carry out constitutional obligations entrusted to the presidency, prosecutors said. Immunity should not foreclose the government from shouldering the burden to prove those demanding standards beyond a reasonable doubt at trial. Trump has pleaded not guilty to a 4-count indictment accusing him of a criminal conspiracy to remain in power, obstruct Congress's lawful certification of Joe Biden's 2020 election victory, and deprive Americans of their civil right to have their votes counted. Trump and his lawyers have accused the Biden administration of targeting Biden's chief political rival and frontrunner for the 2024 GOP presidential nomination, maintaining that Trump acted within the bounds of the presidency to seek to overturn the 2020 results. In seeking to toss his case, they also argued that just as courts have barred lawsuits against U.S. presidents for actions taken within the outer perimeter of their official duties, the same principle should apply to criminal prosecution. They suggested the Supreme Court should take up the question, a legal battle that if joined could postpone his scheduled March 4 trial before U.S. District Judge Tanya S. Chutkan that Trump has sought to push back to after next November's election. No court has addressed whether such presidential immunity includes immunity from criminal prosecution for the president's official act, the lawyers wrote, arguing that Congress's failed impeachment of Trump was the proper venue to decide Trump's guilt or innocence. Prosecutors said Trump's claim directly conflicts with the Constitution, which explicitly provides that presidents impeached and removed from office can be criminally prosecuted for the same conduct. During his impeachment trial, Trump argued as much, saying he could be prosecuted later if the Senate acquitted him, which it did, special counsel Jack Smith's team wrote. Trump would turn the impeachment judgment clause on its head and have the court read it as a sweeping grant of immunity that forbids criminal prosecution in the absence of a Senate conviction, which, among other things, would effectively preclude any form of accountability for a president who commits crimes at the end of his term of office, prosecutors wrote. To the contrary, they argued that the clause was meant to limit Congress's power to removing and disqualifying presidents from office, not to preclude the prosecution of those who escaped removal. They added that temporary legal shield enjoyed by presidents while in office and the ongoing protection they retain from civil liability for official acts once they leave are both premised on the backstop of the availability of accountability for criminal conduct, citing a range of sources including Founding Father Alexander Hamilton's writings in the Federalist Papers and President Gerald Ford's full pardon of his predecessor Richard M. Nixon for any offenses committed during his presidency. Finding otherwise would be startling, prosecutors wrote, freeing from the threat of prosecution a president who accepts a bribe in exchange for a lavish contract for a family member, instructs the FBI director to plant evidence on a political enemy, orders the National Guard to murder his critics, or sells nuclear secrets to a foreign adversary. A president could act with particular impunity in a second term to benefit himself, endanger the republic, or both, a perverse outcome when Trump is accused of a criminal conspiracy to remain in office, Pierce wrote. Even accepting Trump's argument, prosecutors said his alleged crimes did not occur within his official duties but were undertaken as a candidate abusing the public trust. The indictment casts Trump as a habitual liar and sore loser who spewed false claims about purported voter fraud in the 2020 election and then used deceit and lies to try to get state, local and federal officials to change the results to the point of violence in the January 6, 2021, attack on the Capitol. The case is one of 4 felony prosecutions Trump faces, including a state trial in Georgia that involves similar allegations of trying to obstruct the state's election results, a federal indictment in Florida over Trump's alleged retention and mishandling of classified documents and obstruction after leaving the White House, and a New York State business fraud prosecution accusing Trump of covering up hush money payments made during the 2016 election campaign. Washington County Circuit Court judge killed an MD, official says. A judge has been killed in Maryland. The Washington County Sheriff's Office did not immediately respond for comment. A judge was killed Thursday night in Maryland, according to Washington County Circuit Court Administrative Judge Brett R. Wilson. Wilson did not identify the Washington County Circuit Court judge who was killed in an incident first reported by the Herald-Mail media. The Washington County Sheriff's Office did not immediately respond for comment. Supreme Court says White House may continue requests to tech companies. The Supreme Court on Friday temporarily allowed the Biden administration to continue its efforts to get social media companies to remove posts from their platforms that the government says are misleading. The administration had asked the justices to put on hold a lower court ruling that found top officials likely violated the First Amendment by improperly pressuring tech companies to take down what they saw as problematic posts about public health and election-related disinformation. The importance of the issue was underscored by the court's decision Friday to accept the case for oral argument this term, which would mean a ruling before end of June. As is customary in emergency orders, the majority did not explain its reasoning for granting the administration's request. But conservative Justices Samuel A. Alito Jr., Clarence Thomas, and Neil M. Gorsuch dissented from the decision not to leave the lower court order in place, calling the development highly disturbing. The lawsuit against the federal government, initiated by Republican attorneys general in Louisiana and Missouri, raises significant and novel questions about how free speech protections apply online, with implications for how government officials interact with social media companies and communicate with the public on the popular platforms. Jamil Jaffer, executive director of the Knight First Amendment Institute at Columbia University, called the case a significant opportunity for the Supreme Court to resolve an increasingly urgent and relevant issue. The justices have said little about how lower courts should distinguish permissible persuasion from unconstitutional coercion, Jaffer said. These are momentous, thorny issues, and how the court resolves them will have broad implications for the digital public sphere. Missouri Attorney General Andrew Bailey, Republican, called the administration's social media lobbying the worst First Amendment violation in our nation's history. We look forward to dismantling Joe Biden's vast censorship enterprise at the nation's highest court, he said in a statement. In asking the Supreme Court to intervene in the matter, Solicitor General Elizabeth B. Prelogar wrote in a court filing that the order issued by an appeals court last month would impose unprecedented limits on the administration's ability to use the bully pulpit to address matters of public concern and call attention to potentially harmful online content. The lawsuit claims government officials censored protected political speech by urging tech companies to modify posts involving elections and the coronavirus vaccine. Conservatives have long argued that liberal employees inside tech companies are working with Democratic officials to silence conservative views when making content moderation decisions, a claim that tech companies and government officials dispute. Federal interference fundamentally transforms online discourse, rendering entire viewpoints virtually unspeakable on social media, the attorneys general told the High Court in a filing that urged the justices to let the appeals court order take effect. In July, a district court judge in Louisiana sided with the states and issued a sweeping injunction that bars thousands of federal employees across a range of government departments and agencies from improperly pressuring or coercing tech companies to remove specific content. The conservative U.S. Court of Appeals for the Fifth Circuit last month limited that order to the White House, the Surgeon General's office, the Centers for Disease Control and Prevention, and the FBI. The three-judge appeals court panel said the White House likely coerced the platforms to make their moderation decisions by way of intimidating messages and threats of adverse consequences. The panel also found the White House significantly encouraged the platforms' decisions by commandeering their decision-making processes, both in violation of the First Amendment. The opinion details White House efforts to pressure social media companies to remove misinformation about the coronavirus pandemic. Officials were not shy in their requests, calling for posts to be removed ASAP and appearing persistent and angry, according to the ruling. It describes a contentious period in July 2021, which reached a boiling point when President Biden accused Facebook of killing people. We find, like the district court, that the officials' communications, reading them in context, not in isolation, were on the whole intimidating, the judges wrote. The panel subsequently broadened its order this month to extend to government officials with the Cybersecurity and Infrastructure Security Agency, saying those officials probably acted improperly in trying to coordinate with Silicon Valley to protect elections from online hoaxes. The First Amendment protects against government infringement on speech. Officials are permitted to tell a company when content on its website is problematic or misleading, and to advocate for administration policies. But officials cannot coerce private companies to take action on the government's behalf or threaten to punish people for expressing different views. The question for courts to unravel is how to distinguish between permitted government speech and prohibited coercion or threats. Government officials routinely engage with companies like Facebook and YouTube. The FBI, for instance, shares information with platforms about accounts that appear to be used by covert foreign actors to influence the American public. Tech companies and the government expanded efforts to fight against disinformation online after Russian interference on the platforms during the 2016 election. But such content moderation efforts have become embroiled in the nation's culture wars, and many companies are now cutting back on the number of employees who do such work. In its request to the Supreme Court to temporarily block the Fifth Circuit's order while it is appealed, the Biden administration warned of drastic consequences if the limits on government officials are allowed to take effect. There is a fundamental distinction between persuasion and coercion. And courts must take care to maintain that distinction because of the drastic consequences resulting from a finding of coercion, Prelogar wrote. Alito said in his 5-page dissent on Friday that his colleagues should have allowed the lower court's ruling to stand while the High Court resolves the matter. Alito said he doubted the type of bully pulpit speech Prelogar worried about would be prohibited if the Fifth Circuit injunction were in effect. He noted that Biden would not be subject to the appeals court order, which applies only when the government crosses the line to coerce or control the free speech rights of others. Government censorship of private speech is antithetical to our democratic form of government, and therefore today's decision is highly disturbing, wrote Alito, who was joined by Thomas and Gorsuch. At this time in the history of our country, what the court has done, I fear, will be seen by some as giving the government a green light to use heavy-handed tactics to skew the presentation of views on the medium that increasingly dominates the dissemination of news. The Supreme Court has also agreed to review a separate pair of cases about removing controversial material on social media platforms. The Biden administration has asked the court to reverse a decision upholding a Texas law barring companies from taking down posts based on political ideology. That ruling is at odds with a decision from a different appeals court, which blocked a similar Florida law from taking effect. The case accepted on Friday is Morthy v. Missouri. U.S. to appeal sentences of 5 Proud Boys in January 6 Capitol riot case. Prison terms were among the longest for January 6 defendants, but far below government recommendations. The government filed notice Monday that it was appealing the sentences of the 5 members of the far-right Proud Boys group convicted in the January 6 attack, the second such unusual notice by federal prosecutors after a similar filing in July indicating they would challenge the punishments handed down to 5 members of the Oath Keepers for their role in the Capitol riot. In both cases, The prosecutors were not required to file any explanation for their initial notices, but both cases could reflect government dissatisfaction with the length of the sentences, even though the Proud Boys' former leader Henry Enrique Tarrio received the longest sentence yet imposed for the January 6 Capitol riot, and 3 other members received more than 15 years in prison. A spokeswoman for the U.S. Attorney's Office said the filing merely preserves our ability to appeal, though the government typically does not appeal sentences after they are imposed. The seditious conspiracy convictions of Tarrio and Oath Keepers founder Stewart Rhodes were among the most high-profile prosecutions for the Justice Department's sprawling January 6 investigation that targeted organized far-right groups and more than 1,000 others who attacked the Capitol as Congress met to confirm the 2020 Electoral College results. In both cases, the judges imposed sentences well below those recommended by the federal sentencing guidelines, which are only advisory. The prosecution's practice in most January 6 sentencings has been to calculate the guideline range, which combines a defendant's criminal history and the seriousness of the offense, and then propose a sentence in the middle of that range. The judges then calculate their own guideline range, and can go within, above, or below that range. In more than 60% of the January 6 felony cases, the D.C. judges have gone below their own calculated guideline range, and below the prosecution's sentencing recommendations in 80% of all cases, according to a Washington Post database. Sentencing guidelines are not used in most misdemeanor cases. In the Proud Boys case, prosecutors calculated that Tarrio, the leader of the group, should have a sentencing range of 30 years to life, and recommended a term of 33 years. But U.S. District Judge Timothy J. Kelly, a Trump appointee, calculated Tarrio's range at 27 to 34 years in prison, and then gave him a sentence of 22 years. Judges are not required to explain why they deviate from the guidelines, as they were when the guidelines were mandatory. The Supreme Court made the guidelines advisory in 2005. Kelly acted similarly with the other 4 convicted Proud Boys members. Prosecutors sought a term of 33 years for Joseph Biggs, who was on the front lines of the January 6 attack, and Kelly sentenced him to 17 years. Prosecutors sought 27 years for Ethan Nordine, Kelly gave him 18 years. Prosecutors sought terms of 30 years and 20 years for Zachary Rell and Dominic Petsola, Kelly imposed terms of 15 and 10 years, respectively. Nordine's 18-year sentence equaled the term given to Rhodes, the second longest January 6 sentence, after Tarrio. Biggs's and Rell's terms are the next longest of the more than 650 sentences handed down to January 6 defendants so far. We look forward to reviewing whatever the government intends to file as a basis for their appeal, said Naib Hassan, one of Tarrio's lawyers. Hassan added, "We are tediously working on the issues for Tarrio's appeal and believe we will prevail on multiple grounds." Attorney Norman Pattis, who represented Rell and Biggs at their sentencings, said in an email after the notice was filed, "Merrick Garland is unhinged. Period. Call him the Inspector Javert of the DOJ. He should take up bungee jumping. This is no longer my government." Nicholas Smith, Nordine's lawyer, said in an email that his client is encouraged by the government's agreement that errors led to the judgment and sentence in his case. Roger Roots, an attorney for Petsola, called the intended appeal an outrageous abuse of power. "These are already the longest sentences in American history for participating in a political demonstration," Roots said in a statement. Congress was only delayed for 6 hours on January 6. The DOJ is really engaging in overkill. This story has been updated. Officer admits to covering up crash after unauthorized Georgetown chase. Former U.S. Capitol Police Officer Thomas Smith, 46, admitted to covering up an unauthorized vehicle pursuit and collision in 2020 that injured a motorized cyclist. A former U.S. Capitol Police officer pleaded guilty Wednesday to violating an individual's civil rights by engaging in a reckless vehicle pursuit in Georgetown and trying to conceal his involvement in the June 2020 incident that left the rider of a motorized bicycle injured. Thomas Smith, 46, faces a statutory maximum punishment of up to 10 years in prison at sentencing January 22 on one count of deprivation of rights under color of law in federal court in Washington, D.C., according to authorities. In a plea deal, U.S. prosecutors agreed to drop additional counts of making false statements, falsifying police records and obstructing justice, although Smith's conduct counts toward a recommended sentence of 18 to 24 months in prison under advisory federal guidelines. A member of the force for more than 10 years, Smith admitted to participating in an improper chase in Northwest Washington on June 20, 2020. According to plea papers, Smith was on duty and driving a marked sedan past the Washington area homes of members of Congress, making security-related dignitary checks. Shortly after 11:30 p.m., he began pursuing two motorized bicycles at high speed southbound on Wisconsin Avenue NW, between Reservoir Road and M Street, in the Georgetown area, according to court papers. Capitol Police policies prohibit vehicular pursuits outside Capitol grounds, except in emergencies and upon supervisory approval, according to plea papers. Smith did not seek approval or notify a dispatcher that he was involved in a chase, he acknowledged. The police car collided with one of the cycles approaching the M Street intersection, knocking its rider, identified only as WW, into the air before he hit the asphalt roadway, suffering cuts and abrasions, according to court filings. In a signed statement of offense, Smith acknowledged that he drove his cruiser around the unconscious WW and left the scene, taking no action to notify anyone, seek medical assistance or to ensure that no further harm came to WW as he lay on the road. After returning to a police garage with the damaged sedan, the indictment says, Smith attempted to make it appear that he had been driving a Capitol Police SUV that night, not the sedan. He admitted to entering false information about which vehicle he had been assigned and making false entries in computerized logs and false statements to a U.S. Capitol Police sergeant after D.C. police notified the agency of the crash in Georgetown, according to the statement of offense. The rider of the bicycle, William White, sued Smith and the federal government in June, seeking $5 million in damages for his physical and mental health injuries, lost wages, and pain and suffering. In an emailed statement, Smith's attorney J. Michael Hannon wrote that the officer made a mistake that night, which is why he pled guilty. Fortunately, Mr. White suffered only minor scrapes and bruises. And Mr. White is also fortunate that night because he was intoxicated on opioids and FaceTiming as he rode. He had to be sedated in the ambulance, and was treated with Narcan at the hospital before he was released with a Narcan prescription. White attorney Michael Bruckheim responded in an email, Mr. White still suffers from the effects of this incident to this day. Officer Smith would not and does not have any knowledge relating to whether Mr. White was FaceTiming or Mr. White's condition upon arriving unconscious at the hospital because he fled the scene like a coward. His statement demonstrates his ongoing and complete lack of remorse or concern for Mr. White's well-being. Bruckheim and co-counsel Sweta Patel added that White was not told by the government that he was a victim or struck by a Capitol Police vehicle until Smith was indicted and not informed of the officer's plea until Wednesday. As the victim in this case, he had the right to be informed in a timely fashion, Bruckheim said. A federal judge in Washington referred attorneys for White and the Justice Department into mediation for a potential settlement of his lawsuit at both sides' request late last month. Smith is the 10th law enforcement or corrections worker since 2022 that federal prosecutors have indicted with or convicted of civil rights violations, abuse or homicide in D.C. for conduct while on duty. Like all of our law enforcement partners, we know that the overwhelming majority of U.S. Capitol Police officers do their difficult and dangerous jobs honorably and lawfully, U.S. Attorney Matthew M. Graves said in a written announcement of Smith's plea. But former Officer Smith violated the Constitution and abused his position by recklessly engaging in a dangerous pursuit that resulted in an unnecessary collision that could have had devastating results. The U.S. Attorney's Office is committed to protecting the civil rights of all district residents and to holding accountable individuals who violate those rights. Supreme Court agrees with delay on drawing new Louisiana congressional map. The Supreme Court on Thursday agreed with a delay on proceedings that could lead to creating a second congressional district in Louisiana where black voters make up a large enough share of the electorate to have a significant chance of electing their preferred candidate. The justices rejected requests by black voters challenging a map passed by the state's Republican-led legislature to allow a lower court judge to proceed in coming up with a new map. The order indicates that once litigation over the issue is completed, the Louisiana legislature might get a chance to draw a revised map. The court's one sentence and signed order contains no instructions as to what should happen next. As is customary with emergency decisions, it contained no reasoning for refusing to put on hold an order from the U.S. Court of Appeals for the Fifth Circuit, and no noted dissents. But Justice Ketanji Brown Jackson wrote separately to reiterate a previous Supreme Court statement that the litigation should be resolved in time for the 2024 congressional elections. Louisiana is one of several states where battles over redistricting continue after the 2020 census. The outcome of those battles could impact which party controls the House of Representatives after the 2024 elections. The Louisiana case is something of a legal quagmire. Last year, U.S. District Judge Shelley Dick found that the map enacted by the Republican-led legislature dilutes the power of the state's black voters and probably violates the Voting Rights Act. While black voters make up about a third of the state's electorate, only one of 6 congressional districts is drawn to be conducive to electing a candidate who is the choice of black residents. The judge directed the legislature to draw a new map. But it did not, and the legal battle was renewed. In June 2022, the Supreme Court put the case on hold while it considered a similar one from Alabama. The 2022 congressional elections took place under the map approved by the legislature. Louisiana is represented in the U.S. House by 5 white Republicans and 1 black Democrat, Troy A. Carter. This summer, the Supreme Court ruled 5-4 that a lower court had been right to find the Alabama map discriminatory. Those judges have now imposed a new map that creates a second opportunity district for minorities among the 7 congressional districts in Alabama, where about 27% of voters are black. The Supreme Court also released its hold on the Louisiana case, sending it back to lower courts. Although a Fifth Circuit panel is reviewing Dick's decision, she called for a hearing earlier this month to begin drawing a new map. But at the state's request, a different panel of the Fifth Circuit stepped in with a command that Dick stop proceedings in the case, in part because she had not given the Louisiana legislature another opportunity to draw a new map. The individuals and organizations challenging the legislature's map called the Fifth Circuit action an extraordinary and unprecedented circumvention of the district court's docket. A petition from lawyers representing voters and the state NAACP said the panel granted relief that no party has asked for, an opportunity for the legislature to develop its own remedy for the likely vote dilution found by the district court. The legislature imposed its map over a veto from Governor John Bel Edwards, Democrat, and has not shown interest in creating a new one. In his brief to the Supreme Court, Louisiana Attorney General Jeff Landry, Republican, said the Fifth Circuit panel's halt to lower court proceedings kept the case from devolving into procedural chaos, making it impossible to resolve the plaintiff's claims before the approaching congressional election cycle. Landry said the state would have been deprived of the chance to defend itself if Dick had been allowed to proceed, and the Louisiana legislature would have lost the opportunity to draw a new map in the first instance that conformed to the district court's order. Louisiana's qualifying deadline for the November 2024 election is about 8 months away. Eli Lilly targets firms that import and sell imitation Mounjaro online. Mounjaro is one of a new class of diabetes drugs that are coveted for their weight loss side effects. Eli Lilly filed a complaint with the U.S. International Trade Commission on Thursday to block companies from importing and selling cheaper versions of its blockbuster drug Mounjaro online, accusing them of misleading and endangering American consumers seeking to lose weight. The Indiana-based drug maker accused 11 companies of importing products that they say contain tirzepatide, the active ingredient in Mounjaro, while falsely implying that their products are associated with Eli Lilly or approved by the Food and Drug Administration. One company selling tirzepatide online advertises that its product has a purity greater than 99%, however, according to Eli Lilly, it is actually just sugar alcohol. By suggesting that their products are equivalent to FDA-approved Mounjaro, Eli Lilly says, the companies are cutting into its sales and engaging in conduct gravely dangerous to consumers who unknowingly inject themselves with research chemicals not designed or intended for use in humans. Eli Lilly's complaint is the latest legal battle over sensationally popular medications that treat diabetes and also suppress appetite, helping people achieve unprecedented degrees of weight loss with once-a-week injections. Eli Lilly and Novo Nordisk, the maker of Ozempic and Wegovy, have also sued compounding pharmacies and med spas that make and market off-brand versions of their FDA-approved drugs. The complaint to the Trade Commission, however, targets companies that sell their compounds directly to consumers online, often without a prescription that would be required for Mounjaro and other FDA-approved drugs. Eli Lilly is seeking an order from the federal agency that would bar all imports of products that violate fair trade provisions, such as the infringing of its trademark, as well as cease and desist orders to the individual companies it has targeted. An examination by the Washington Post found more than 24 websites selling tirzepatide or semaglutide, the active ingredient in Ozempic, that generally say they are for research use only. One website refers to this as a disclaimer to stay in business. The operator of another site openly acknowledged selling them to people, saying the products were safe. Eli Lilly targeted companies that it says import their products from overseas, selling them for about a tenth of Mounjaro's $1,000 list price for a month's supply. The firms can undercut Eli Lilly on pricing, the drugmaker says, by using cheaper foreign labor and inferior ingredients and processes. At the same time, Eli Lilly argues, the companies are effectively piggybacking on Eli Lilly's research and development of Mounjaro by referencing the drug by name, referring to its FDA approval or citing Lilly's clinical trials. These factors, coupled with the ease of buying the imitation products online, cause substantial injury to Lilly's domestic industry, the company says. In one example, Lilly cites a Chinese company doing business as Ostropeptide that sells tirzepatide online. Although the website doesn't mention the FDA, Lilly argues that Ostropeptide's description of the compound is intended to mislead a purchaser into believing that its products have been approved by FDA for human drug use when they have not. Lilly's own testing found that the product did not contain any tirzepatide but was instead consistent with a common sugar alcohol, according to the complaint. Ostropeptide did not immediately respond to a request for comment. The FDA has warned consumers against buying compounds from unlicensed sources. Earlier this month, the agency issued warning letters to 2 firms selling weight loss compounds online for what it called illegally marketed semaglutide. Eli Lilly brought in more than $1.4 billion from selling Mounjaro in the United States for the first half of 2023, according to its financial statements. Mounjaro, as well as Eli Lilly's other weight loss prospects in development, have helped boost its stock price by 60% so far this year, giving it a stock market value of about $560 billion, the biggest of any U.S. pharmaceutical firm, according to S&P Global Market Intelligence. Mounjaro, Ozempic and Wegovy have proved so popular that their manufacturers haven't been able to keep up with demand, leading the FDA to declare the drugs in short supply. That designation has opened the door for compounding pharmacies to mix up versions of the FDA-approved drugs, giving rise to an industry built on selling the off-brand versions cheaply. Eli Lilly emphasized in the complaint that it has invested heavily in expanding capacity to make Mounjaro. As of Thursday, all dosages of the drug were listed as available on FDA's drug shortage database, though the agency hasn't yet removed it from the list. We don't resolve a shortage until the national demand is being met, which includes the firm being able to fill all orders, with no back orders and safety stock built up in reserve to prevent further intermittent back orders, an FDA spokesperson said. How did McDonald's become a new flashpoint in the Israel-Hamas war? Beirut, as Israel's war in Gaza spreads anger and anxiety across the Middle East, one of America's most famous brands has found itself in the thick of it, McDonald's. It all started earlier this month when a McDonald's franchise in Israel run by Alonial Limited said it would provide free meals to Israeli soldiers as well as hospitals. Franchises elsewhere in the Middle East were quick to distance themselves, saying they had nothing to do with the decision to serve soldiers, and some began making donations to Gaza in solidarity with the Palestinians. Then, in the wake of a horrific strike on a Gaza hospital that killed hundreds, several branches of the chain were vandalized in Turkey, Lebanon and Egypt. With more than 40,000 stores worldwide at the end of 2021, McDonald's is one of the globe's most recognized brands and is closely associated with America, even though the vast majority of the restaurants are locally owned under the franchise system. Over the years, the stores with their highly recognizable golden arches have been repeatedly targeted as symbols of the United States, especially in the Middle East. Unlike U.S. embassies with their concrete walls and police protection, McDonald's and other fast food franchises have been easy marks for politically motivated vandalism. The emergence of McDonald's as a flashpoint harks back to an era of Arab boycotts of American brands in the early 2000s. During the Second Palestinian Intifada and after the U.S.-led invasion of Iraq. During the Arab Spring protests in Cairo in 2011, the fast food restaurants around Tahrir Square were attacked, gutted and turned into first aid stations for protesters. The current storm over the hamburger chain has intensified as the death toll has soared in Gaza following nearly 2 weeks of Israeli bombardment, sparked by a deadly Hamas incursion into Israel. A week into the crisis, franchises in Turkey, Egypt, Jordan and Lebanon and across the Persian Gulf released statements distancing themselves from the actions of their Israeli counterparts. What the licensee in Israel did was an individual and private act, and not with the approval or direction of the international company or any other licensee, especially in our Arab world, read a statement released by Al Mashirji Catering Company, which operates McDonald's Kuwait. Franchises in Qatar, Kuwait, Oman, Turkey, Bahrain, the United Arab Emirates and Saudi Arabia donated money to Gaza. Others, in Egypt, Lebanon and Jordan, released statements but only later, under pressure, offered money. The McDonald's Corporation, responding to an inquiry about its franchisees' political and charitable activities, said Saturday that the company's top priority was ensuring the safety of its people and teams on the ground. But the gestures have not stopped calls for a boycott of the fast food company, as well as attacks on some locations. In Egypt, boycott calls quickly circulated online as many people took to social media to express their anger. This famous restaurant, which gives food to Israel, which we eat every day and has locations in all of Egypt, we all know it, but I can't name it. This restaurant as of today should not be around. This is the least we can do, said TikTok star Ahmad Nagy, speaking with a blurred photo of the golden arches behind him in a video that has so far received 1.3 million views. The vitriol spurred a popular Egyptian talk show host, Amr Adib, to tell his viewers on October 14 to not boycott the local franchise because it is owned by the Egyptian billionaire Yassine Mansour and provides jobs to countless Egyptians, he said. What is the point of closing McDonald's? What is the point of hurting this man and hurting people's livelihoods, he said. Egypt's franchisee, Manfoods, said in a statement that it provides more than 40,000 job opportunities directly and indirectly for Egyptian citizens. In response to these concerns, Tafwela, a local restaurant, posted an ad on Facebook offering to hire McDonald's defectors. Anyone who wants to stop working at places that support those who kill our brothers, talk to us, and God willing, we will give you a good salary. In a viral post on TikTok, Egyptian influencer Ali Ghazlan called McDonald's out for not showing support to Gaza. Just release a post, one post saying, I support our family Gaza. In response to the criticism, Manfoods on Sunday announced that it would donate 20 million Egyptian pounds, $650,000, for relief efforts in Gaza. McDonald's Egypt today announced that they'll donate 20 million pounds for the cause. I'll say this again, your voice can make a difference, and this is the result, Nagy said in a TikTok. Meanwhile, in Israel, the local McDonald's franchise has had to battle rumors that it's supporting the Palestinians, threatening legal action against anyone spreading such stories. It said on its X account that it has donated 100,000 meals to security forces and local hospitals and is offering 50% discounts to members of the rescue and security forces. Calls for boycotts of McDonald's are not uncommon in the region. During the Second Intifada, McDonald's and other American products faced boycott calls across the Arab world. At the time, Reuters reported that the franchisor of McDonald's Saudi Arabia responded by raising money to donate to Palestinian hospitals. Egypt's operator took out a full-page ad in the local daily Al Aram saying it employed 3,000 people. In 2003, after the start of the Iraq War, a McDonald's in Beirut was targeted in a bomb attack, wounding 5. A 2008 University of Minnesota study found that American multinational corporations such as McDonald's adopted strategies such as making donations and emphasizing the impact on the local economy to quell boycott calls during the Second Intifada. It also spurred them to localize their offerings by introducing items such as the McFalafel in 2001. In Gaza war, Qatar revisits role as regional mediator. After the release Friday of 2 Americans held by Hamas, officials in Israel distributed images of the women walking hand-in-hand to freedom with an Israeli envoy, and U.S. authorities shared photos of the pair talking by phone to President Biden. The Persian Gulf nation of Qatar was where it preferred to be, a bit out of the picture but very much in the mix. Over the years, the tiny, energy-rich state has leveraged its extensive diplomatic relationships, including with militant groups like Hamas and the Taliban, and U.S. adversaries including Russia, to negotiate delicate issues during international conflicts. The release of the Americans, Judith Ronan and her daughter Natalie Ronan, of Evanston, Illinois, marked the third time in 2 months that Qatar's mediation has played a role in facilitating negotiations between bitter adversaries. In September, Qatar helped secure the release of 5 Americans held by Iran. Earlier this month, Qatar was in the middle of an effort to free Ukrainian children held by Russia. Here's what to know. How was Qatar involved? The Ronans were the first of more than 200 captives believed held by Hamas since the militant group's deadly attack on Israel 2 weeks ago. Hamas said in a statement that they were released at the request of Qatari mediators for humanitarian reasons. The mediation that led to the release of the Ronans was part of an effort Qatar said it hoped would lead to the release of all civilian hostages from every nationality held by Hamas. Majid Ansari, a spokesman for Qatar's Ministry of Foreign Affairs, said in a statement Friday. It came after days of continuous communication between all parties involved, he added, saying the effort aimed at de-escalating the current crisis. Why does Qatar have leverage? Qatar, a strong supporter of the Palestinians as well as regional Islamist movements, has maintained ties with Hamas going back nearly 2 decades. In the past, Qatar tried to mediate disputes between Hamas and the rival Palestinian Fatah movement in the West Bank. In 2012, Qatar's then Emir, Sheikh Hamad bin Khalifa Al Thani, became the first head of state to visit Hamas-controlled Gaza, pledging hundreds of millions of dollars of aid. Hamas leaders have been hosted in Doha, Qatar's capital, for years. Qatar has also kept low-level relations with Israel at a time when other Gulf nations were firmly opposed to any outreach. In the 1990s, Qatar allowed an Israeli trade office as the country's only outpost in the Gulf. After taking over from his father, the current emir, Tamim bin Hamad Al Thani, has declined to follow some of Qatar's neighbors in fully normalizing relations with Israel. Qatari officials said that such a step would only follow peace between Israel and the Palestinians. What are Qatar's other mediation initiatives? A gas-rich state of 2.7 million people, Qatar has tried to exert influence in regional and global affairs, including through mediation efforts that began in earnest in the mid-2000s, according to Sultan Barakat, a professor at the Qatar Foundation's Hamad bin Khalifa University. Barakat wrote a 2014 paper about those initiatives, including early attempts to mediate in Yemen, Lebanon, Sudan, and between Israel and Hamas. Prior to 2011, these efforts produced mixed results, he wrote. Beginning that year, as pro-democracy protests spread around the Middle East, Qatar was less noticed for its diplomacy and more closely associated with support for the Arab Spring uprisings as well as Islamist groups involved in the revolts. These interventions earned Qatar the ire of regional powers, including the United Arab Emirates and Saudi Arabia. Tensions with neighbors came to a head in 2017. Saudi Arabia and others, angered by Doha's ties with militant groups, Iran and its sponsorship of the Al Jazeera news channel, imposed a years-long economic blockade of Qatar, cutting links by land, sea, and air. What are the benefits and risks to Qatar? The diplomatic foray is part of a package of soft power initiatives Qatar has used to buttress its global standing and distinguish itself from regional rivals, an effort that includes hosting campuses of American universities and supporting sports teams, including staging the 2022 World Cup. The mediation, especially when it benefits the United States, is also used as a guard against some of the criticism Qatar has received for supporting groups considered terrorist entities by Western countries. Qatar, which has maintained relations with Afghanistan's hardline Taliban movement for years, played a key role in 2021 assisting the United States evacuate its citizens and allies during the chaotic American withdrawal from the country. If Qatar stopped its engagement with the Taliban, Qatar's foreign minister, Mohammed bin Abdul Rahman bin Jassim Al Thani, said at the time, "We are going to leave a vacuum." The question is, he added, who is going to fill this vacuum? Biden hails freed U.S. hostages as family awaits reunion. "We're going to get them all out, God willing," the president told Judith and Natalie Ronan of others held captive by Hamas. President Biden told the American mother and daughter released by Hamas militants after 13 days in captivity that he was just delighted about their freedom and pledged to work toward the release of other U.S. hostages. During a call Friday, Biden told Judith Ronan, 59, and her daughter Natalie, 17, that he was so glad you're out, according to a video clip of the call released Saturday by the White House on social media. "We've been working on it a long time," Biden said, addressing the pair through a speakerphone on his desk in the Oval Office. "We're going to get them all out, God willing. I just want to say thank you for your services for Israel," Natalie told the president during the call. He responded, "Look, that's been long-serving." The conversation came hours after the Ronans were released by Hamas authorities to the Red Cross in Gaza. The pair were reportedly reunited with family members in Israel. They had been staying with relatives at the Nahal Oz, a kibbutz near the border with Gaza, when they were taken captive on October 7 during an attack on Israel by the militant group. Hamas said it released them at the request of Qatari mediators for humanitarian reasons, though it still remains unclear why they were the first hostages set free. More than 200 are believed to be held by Hamas, including at least 10 Americans, authorities said. Yuri Ronan, Natalie's father, told the Washington Post on Saturday that he spoke with her briefly Friday, and she told him she is feeling good. "She told me she's good, everything is okay, she looks good," he said. "I haven't talked to her since then." He added that he hopes to be reunited with his daughter early next week, when he said she could return to her home in the Chicago suburbs. Her birthday is Tuesday. Yuri Ronan said he has not spoken to Judith, his ex-wife. He said family members were hopeful when they first heard news reports that Hamas was planning to release a mother and daughter. Then he received phone calls from the FBI and the Israel Defense Forces saying Natalie and Judith had been set free. "Everything came so fast," he told the Post. "I have been more than thrilled." In a statement for the family, Ayelet, and Lamor Sella, relatives of Judith and Natalie, thanked Biden, Congress members and others who helped press for their release. They said they have 8 other family members who remain hostages. "We remain entirely focused on the efforts to secure the return of all the other hostages," they said. "We will work around the clock with the other families of those held hostage until each and every one of them is back home." Rabbi Meir Hecht, co-director of the Chabad House in Evanston, Illinois, told reporters on Friday that Judith Ronan was a regular member of the Orthodox congregation for more than 10 years. "While we continue to be so happy and thankful for Natalie and Judith coming out of the hands of murderers, we also want everyone to continue to pray for the rest of the hostages," Hecht said, according to video of the remarks. Hecht said friends were looking forward to a huge celebration upon their return home. "Goodness will prevail. Don't give up," Hecht said. "Terrorists want to make us hopeless. We have to tell them we stand proud, we stand strong. And our prayers do get answered." Documents found on fighters reveal Hamas capabilities, bloody plans. Ashkelon, Israel, a Hamas field manual obtained by the Washington Post and other documents found in the wake of the group's brutal attack on Israel 2 weeks ago illustrate some of its military capabilities and preparations for close-in, bloody killing. The manual, dated last year and found on the body of a Hamas fighter, lists instructions on operating certain weapons, identifies vulnerabilities in Israeli military equipment and offers tips on killing with a knife. The document appears to have been prepared for different units of Hamas's elite Izzadin al-Qassam brigades, including anti-armor, engineering, sniper, infantry, and tunnel specialists, as well as what the booklet describes as shock troops. "This is a secret military document," the first page begins. "It should be kept in a safe place. It is forbidden to move with it except when there are orders." On its back cover is a picture of the Palestinian Sheikh Abdullah Azzam, a mentor of Osama bin Laden. "If this is their source of inspiration, and this is the figure, the symbol, they are looking at, I understand something more about their behavior on October 7, said Michael Milstein, a former head of the Palestinian Department in Israeli military intelligence, referring to the date of the attack that left 1,400 Israelis dead. Milstein examined the field manual at the request of the Post. Experts, including Milstein, said the manual appeared to be genuine and matches a cache of other documents gathered by Israeli forces and first responders following the attack. The Israeli Prime Minister's office has verified 17 pages of documents for the Post. Some documents, including the field manual, were not provided for verification because of identifying marks that could identify who first found them and gave them to the post. Others, Hamas documents, have included maps and detailed plans for attacks on several individual kibbutzim around Gaza, including the intention to kill and kidnap civilians. The document obtained by the Post provided guidance on operating weapons that they are known to have carried and also offered detailed descriptions on the vulnerabilities of Israeli tanks and armored vehicles. Included, for instance, are instructions for using North Korean F-7 rocket-propelled grenades, which Pyongyang has denied supplying to Hamas. Around 50 of the high-explosive munitions were found by Israeli troops following the attacks, according to the military, which has displayed some of the material it found. Hamas officials in Gaza and Beirut did not respond to requests for comment. Hamas's secretive military wing Al-Qassam is estimated to have built a force of anywhere between 15,000 and 40,000 combat-ready fighters, 1,200 of whom it has said were involved in the October 7 attack. In earlier years, when tunnels were open to Egypt, Hamas could easily smuggle in explosives and rockets to Gaza, said Nkamar Abusada, an analyst at Gaza's Al-Azhar University. But Egyptian President Abdel Fattah el-Sisi has clamped down on smuggling routes. Honestly, I don't know how they have kept up their ability to build this military capability, Abusada said, noting the security perimeter around Gaza. Members of Al-Qassam's elite Nukba special forces that spearheaded the assault are known to have been trained in Iran and have returned to Gaza to train others, he said. Militants used paragliders, motorbikes, and trucks to cross the border fence from Gaza into Israel, and small specialized units attacked Israeli communities, in line with the instructions in the handbook. We saw they are working as professional troops, said Major G., a commander of the Israeli Institute for Weapons Research on Friday, as he displayed weapons that had been seized from Hamas. The major could only be identified by his rank and first name under rules set by the Israeli briefers. They worked very specifically. It was very organized. One vehicle is IED, one vehicle was RPGs, one vehicle was a command team. The instructions for shock troops also included the best places to stab someone, according to the field manual obtained by the Post. The neck and the collarbone area, spine and underarms are listed. Ayman al-Tamimi, an expert with the Middle East Forum who has extensively studied documents recovered from battlefields in Iraq and Syria, agreed that it appeared genuine. It wouldn't be surprising for documents like this to be in the possession of fighters, he said. The Israeli military says hundreds of documents and other material have been collected by the Intelligence Directorate and the Yahalom Combat Engineering Unit, including Hamas cell phones, communication equipment, cameras and intelligence reports. Many documents have emerged in a Telegram channel called South First Responders, which compiles evidence gathered in the aftermath of the attacks by those clearing the areas. The group declines to answer questions on its methods for gathering documents and material, citing risks to sources. Those who have worked to remove the bodies of hundreds of Palestinian militants killed in the assault say that corpses are first checked over by bomb squads to make sure there are no hidden explosives. They came with everything, fully equipped, with documents, maps and instructions, said Yossi Landau, a frontline responder with the Zaka Medical Organization, which has been working to remove bodies. One 14-page document partially posted by South First Responders and verified by Israeli authorities outlined attack plans for Mafalsim, a small kibbutz of 1,000 people that managed to escape relatively unscathed from the attack. Kibbutz security fought off a group of around 30 militants armed with grenades and AK-47s at the front gate. The document details the size of the kibbutz security team, the number of minutes it would take to travel between various points in the community, and the goal to take soldiers and civilians as prisoners and hostages and negotiate their release. According to 4 additional pages obtained by the Post, the team at the front gate was supposed to distract the kibbutz security force while a Hamas explosives unit blew a hole in the back gate. The group keeps the kibbutz busy until the rest of the forces arrive, the planning document said. But the reinforcements never arrived, according to those that fought in the kibbutz. They knew where the gates were, they knew where the generators were to cut the electricity, said Yarden Reskin, a landscape architect and volunteer on the security team at the kibbutz. Looking at the attack plans, and the death toll in surrounding communities, we do feel like we had a lot of luck, he said. We did our part, we did it good, but we had a lot of luck. Hendricks reported from Jerusalem.